What these tests show was that there was a high degree of serious violence perpetrated by Mr. Depp toward Ms. Heard. There was violence more on the mild level perpetrated by Ms. Heard toward Mr. Depp.
A familiar face from a very familiar trial may be making her way back onto the stand, this time in the high-profile criminal trial of Sean Combs. Will the doctor who testified on behalf of Amber Heard now be permitted to testify for federal prosecutors against Diddy? We're going to break down the recent arguments from the rap mogul about why her testimony should be excluded. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Interesting situation we have here. So federal prosecutors want to call a key expert witness to the stand at Sean Combs' upcoming criminal trial planned to start next month. You know, the case where he's facing racketeering, prostitution, and sex trafficking charges. But the defense says no. She should not be allowed to testify. And there is a lot about this. So who is this person? We're talking about Dr. Dawn M. Hughes. Now, there is a chance you might be saying, why do I know that name? Why does that sound so familiar? Well, go back 3 years ago. Can't believe it's been 3 years, but you go back 3 years ago, and you remember the defamation trial of Johnny Depp and Amber Heard back in Virginia? Well, she was called by the actress to opine on her mental health and whether or not Amber Heard was exhibiting signs of, in fact, being abused, because Heard had been sued by Depp for falsely accusing him of abusing her.
Did you arrive at any expert opinions?
Yes, I did.
All right. I'd like to start with your main expert opinions and then go through those. Can you please tell the jury what your main opinions were?
So like I said, there are opinions embedded within them, but the main opinion is that Ms. Heard's report of intimate partner violence and the records that I reviewed is consistent with what we know in the field about intimate partner violence, characterized by physical violence, psychological aggression, sexual violence, coercive control, and surveillance behaviors.
And what was the other main opinion that you had?
The second main opinion was that that Ms. Heard demonstrated very clear psychological and traumatic effects, or the exacerbation of trauma, from those statements that Mr. Depp made through his attorney. There were 3 statements that we evaluated to see how they affected her emotionally and psychologically, and it was my determination that they did.
And did you arrive at any diagnostic conclusions?
Yes, I did.
And what were those?
I diagnosed Ms. Heard with post-traumatic stress disorder.
By the way, after she testified, there was this WebMD profile of her that was reportedly slammed with negative comments, including accusing her of hating men. Now, not sure when that reporting came out if that was all because of her testimony and this was such a polarizing trial. But I'll tell you what, now she may be testifying in another high-profile, massive trial. The difference is this is a criminal case, and there's not going to be cameras. There's no cameras in New York federal court, although there will be a transcript of her testimony, and we're going to be reporting on it nonetheless. So it's going to be interesting because she is planned to testify in arguably 2 of the biggest trials in the last 5-10 years. But here's the question. Will she testify? By the way, as you know, we have been trying to cover every important update in this Diddy case for you. And for that, gotta call out and thank our amazing sponsor, Upside, because their support helps us to keep on doing this. Now, Upside's awesome. It is a free app that gets you cash back when you buy daily essentials. So I pump my gas, I can use Upside. I go out to lunch at Chipotle, I can use Upside. Maybe I get gum or Tic Tacs at 7-Eleven, I can use Upside. And why not get cash back when I do all these things, right? And yes, this is actual, real cash back. It's money that appears in your Upside app that you transfer right into your bank account. So once you have the free Upside app, you claim an offer for whatever you're buying on Upside. You pay as usual using a debit or credit card. You follow the steps on the app, you get paid. So to find out how much you can earn, click the link in the description to download Upside or scan the QR code on screen and use our promo code SIDEBAR and you'll get an extra 25 cents back on every gallon on your first tank of gas. So before I lay out Sean Combs' arguments for why her testimony should be excluded, here's a little bit more about what we know of Dr. Dawn Hughes. So it's in an exhibit that was filed in this case, and it's called Disclosure as to Expert Witness Dawn M. Hughes, PhD, ABPP. Dr. Hughes is a clinical psychologist and a board-certified forensic psychologist, and a leading expert on sexual abuse, interpersonal violence, victimization, and traumatic stress. The following includes the anticipated opinions the government expects Dr. Hughes will offer regarding sexual abuse and victim responses to sexual abuse, coercive control, coping strategies during and in relation to sexual abuse, delayed disclosure, and memory of sexual abuse. Quote, the government expects that Dr. Hughes will testify about coercive control as a tactic of victimization, i.e., the state to process of becoming a victim, and a strategy to gain dominance across a spectrum of relationships. Coercive control often includes a variety of physical, sexual, and/or emotional tactics that together function to control the victim. More specifically, Dr. Hughes will explain that these tactics may include, among other things, the following: actual or threatened physical violence, aggression, sexual assault and abuse, sexual degradation, micro-regulation, financial and economic control, control over reproductive health, control through the use of drugs or alcohol, physical and emotional isolation from pre-existing support networks and external influence, use of collateral or damaging or compromising information, exploitation of pre-existing psychological, traumatic, or financial vulnerability, psychological degradation and humiliation, gaslighting, and surveillance techniques limiting privacy and independent thought and instilling the belief that the perpetrator is omnipresent. Okay, so here's the thing. In a case where Combs is accused of using force, fraud, or coercion to compel women to engage in commercial sex acts such as freak-offs and using violence, threats, drugs to keep them compliant and get his way, where you have 4 listed, currently unidentified victims in the most recent indictment, you can understand the potential significance of Dr. Hughes' testimony, right? To have these alleged victims testify and then have Dr. Hughes potentially explain certain behaviors or actions as evidence of abuse. And that's important because you may have alleged victims who claim they were sex trafficked or victimized by Sean Combs, but decided to stay in a relationship with him or stay in contact with him or acquiesce to his demands or forget certain details or not report it immediately or whatnot. Now, we don't know for sure, but I think that's a fair estimation. And Dr. Hughes could testify for the prosecution and suggest that all of this is consistent with what has been seen in other abuse survivor stories. And it doesn't mean that these women aren't telling the truth about what happened. Now, the defense doesn't want her to testify. And that is quite clear in their motion in limine to preclude testimony of Dr. Dawn Hughes. So a motion in limine is a pretrial motion to prevent certain evidence from coming into trial, being seen or heard by the jury, or limiting it in some way. So I want to dive into this. It starts off by reading, quote, the prosecution seeks to call Dr. Dawn Hughes as an expert witness to offer opinions about typical behaviors among perpetrators and victims of abuse and sexual violence. Hughes has not reviewed or evaluated any of the evidence in this case. While purporting to offer only background information, her opinions are skewed to advance the government's themes, and her testimony will mirror that of the government's fact witnesses. Her testimony's only real purpose is to support an inference that because the accusers in this case behaved in typical ways, they must be telling the truth. Hughes' testimony should not be admitted. And Combs' team even writes, quote, Hughes' testimony is advocacy masquerading as expertise. Wow. So something just to keep in mind, there is an argument here, right? If she didn't have an opportunity to evaluate and analyze these 4 alleged victims and speak with them, her testimony has to be limited. It has to be general and provide background information. So keep that in mind. Now, first, Combs explains that courts have a legal duty, a, quote, gatekeeping role, to avoid significant risks that can come from expert testimony and to avoid junk science. In order to do this, Combs explains that under the rules of evidence, before an expert can be allowed to testify, the party who is proposing the expert has to establish a few things. 1, the expert's scientific, technical, or other specialized knowledge will help the trier of fact, meaning here the jury, to understand the evidence or to determine a fact and issue. 2, the testimony is based on sufficient facts or data. 3, the testimony is the product of reliable principles and methods. And 4, the expert's opinion reflects a reliable application of the principles and methods to the facts of the case. Quote, Hughes' broad testimony on matters already familiar to jurors will not help the jury understand the evidence. Rather, it will usurp the court's role in giving the jury the law and the jury's role in deciding credibility. Hughes' opinions are also not reliable, both because they lack an adequate basis and because they are stated at such a high level of generality that they can hardly be tested and will serve merely as rhetorical handlebars for the prosecution in its summation. A lot of words there. I'm going to break it down step by step. I want to begin, though, with the idea that, according to Sean Combs, Dr. Hughes is really not going to help the jury understand anything. This is, again, one of the first factors that we talked about. So Combs argues that Hughes will provide opinions on topics that are already within the jury's everyday knowledge, and that this isn't going to help the jury understand the evidence, namely that her testimony, quote, is full of broad generalities based on common sense and general life experience, not expertise. For example, Combs argues that Dr. Hughes will educate the jurors on gaslighting and love bombing, but as the defense asserts, quote, these are not scientific or technical concepts. They are rather concepts of pop psychology and pop culture. Any juror who reads a newspaper, uses social media, or watches television knows what gaslighting is. There's no need for an expert to take the stand and explain it. And in terms of Dr. Hughes testifying that abusers exploit power dynamics, you don't need an expert to testify to that either, Sean Combs argues. A prosecutor could easily argue about power differentials and targeting of victims' vulnerabilities in a closing argument, in a summation. The jury already gets it. So Combs also argues that Hughes plans to testify that victims of abuse may resort to drugs and alcohol. But Combs argues that's already obvious to jurors. And moreover, Combs claims that Dr. Hughes' testimony relies on, quote, condescending and elitist assumptions of what jurors don't understand. That while she may testify that sexual assault is common, or most sexual assaults are committed by those people known to the victims, and that some victims don't report the assaults, Combs argues none of that is new. Are you assuming the jurors harbor rape myth viewpoints? You have to assume that either the jurors themselves are assault victims, or maybe they know of someone else who was sexually assaulted. In other words, jurors already know all this stuff. My take, interesting argument. Definitely an interesting argument, although I am not sure the court will necessarily agree. I've seen experts testify before about topics that would seem to be relatively straightforward or known, but were permitted. And look, sexual assault can be a bit complicated. It can be nuanced, especially since our understanding and the study of it has changed over the years. Then again, maybe not. Maybe Combs makes a good argument. From there, Combs' counsel argues that Dr. Hughes will improperly and misleadingly instruct the jury on the law. And you can't have that. Can't have an expert usurp the role of the judge, who's the one that instructs the jury on the law. And the reason Combs' counsel argues this is because they claim she's going to provide legal definitions that will confuse the jury. Quote, for example, Hughes offers to define sexual assault. Sexual assault refers to contact and non-contact sexual violations, including voyeurism. So they're basically saying that is what her definition of it's going to be. But sexual assault is a term with a legal meaning. Jurors already know, as a general matter, what sexual assault means in a colloquial sense. And if they need to apply a legal definition, that definition must be given through jury instructions, not expert testimony. But Combs' counsel argues that this will get really bad when it comes to the term coercion. And there are numerous alleged acts of coercion in the indictment. And when you look at the federal sex trafficking statute, it is very precise and specific as to what coercion means. So Combs argues that that is the definition that the jurors will have to apply in this legal case. But, quote, Hughes also proposes to testify about what coercion means in the context of her discussion of the concept of coercive control. And her definition is different from the legal definition. According to Hughes, coercive tactics can include not just violence and threats, but a variety of other subtle tactics, including ostensibly positive behaviors such as rewards, positivity, affection, and normalcy, which can create emotional attachment and psychological dependency. According to her, anything counts. And then Combs provides a specific example. Quote, the evidence in this case will show, for example, that Combs financially supported his girlfriends. That does not count as coercion under the legal definition, but it would count under Hughes' definition. Suppose the evidence shows that after a fight, Combs apologized, expressed love, and bought his girlfriend a gift. That would not count as coercion under the legal definition, but it would count under Hughes' definition. By the way, this is the defense interpretation of the federal sex trafficking law. The prosecutors might disagree. And then Combs cites case law in support of the idea that expert opinions that provide definitions of concepts that are different from legal definitions, those are admissible. Again, to the idea that an expert can't, quote, compete with the judge in the function of instructing the jury. Now, I actually think that this is a stronger argument. Confusion regarding definitions of overlapping concepts and terms could be a real issue. Perhaps the judge would instruct her not to make those definitions. But then Combs and his counsel cite another issue with Dr. Dawn Hughes' testimony, or planned testimony, that Dr. Hughes is going to make broad generalizations about behavior or fact patterns that will mirror what the alleged victims will testify to. And this is just a way, he claims, to improperly make them, these alleged victims, seem more credible. And that is not right. That's not permitted according to his analysis. Combs' counsel writes, "A criminal trial is not a college seminar. Opinions about things that are commonly seen or often seen or typically seen or that may occur in sexually coercive relationships may be a subject of academic interest, but such opinions have no place in a courtroom because they do not help the jury reach the truth in the actual case before them." The government may not prove a narcotics offense, for example, by arguing that the defendant's actions matched an expert's description of the typical operating methods of drug dealers in a particular neighborhood. So here, the argument is that Dr. Hughes will testify that the fact patterns the alleged victims describe are commonly seen in coercive relationships and explain away memory lapses and failure to remember details and failure to leave abusive relationships. And the prosecution will use that general analysis to say that the alleged victims are telling the truth. Quote, "The defense cross-examined victim 1 about this, about that, but as Dr. Hughes told you, all of that is normal. In fact, that's how it typically goes in these situations. The use of generalized expert testimony to build a scaffold for witness credibility is fundamentally improper." Now, that is a very creative argument. I imagine the prosecution would counter this and say, isn't that the point of a lot of expert testimony? You have experts who provide testimony that supports the case, supports the testimony of key witnesses or victims or defendants. That's common. I mean, here's an example. Defendants calling use of force experts in shooting cases. Yes, they may testify generally about when to use deadly force, and that description or fact pattern can mirror what the defendant testifies to. But Combs' team doesn't end there. They present another argument that Dr. Hughes will improperly speculate about motives of people who engage in sexual coercion, and courts have disfavored that kind of testimony. Here, it could be, quote, "The perpetrator engages in self-centered behavior to satisfy his own goals and desires regardless of the needs, wants, and well-being of the victim." Yeah, I do wonder if this could be a situation where the judge is not going to exclude Dr. Hughes' testimony entirely, but prevent her from opining on certain things, like opining on the motivations of a perpetrator. Again, there does seem to be a value to her testimony to educate jurors on certain complexities of sexual coercion, abuse, power dynamics, behavior, actions, but maybe she won't be allowed to testify about everything. Now, everything I've discussed so far was about whether the expert will help the jury, one of the factors in the expert testimony admission analysis. But Combs then moves on to another factor and asserts that Dr. Hughes' opinions are not a reliable application of scientific principles. So for one, Combs argues that her opinions are not supported by the literature she claims to rely on. Quote, "Several examples show Hughes' troubling tendency to overread or outright disregard the very literature she cites. This is because the phenomena she undertakes to describe are far more complicated than the simplistic distillations she provides." For example, Combs argues that while Hughes claims the research shows sexual abuse is considered among the most underreported crimes, according to Combs, the report that Dr. Hughes cites says that in 2023, the percentage of assaults and rapes reported was actually higher than the overall reporting percentage for all violent crimes. Combs further argues that while Hughes provides a concrete definition of coercive control in one of the articles that she cites, it's explained that coercive control is really undefined, and other sources don't help her either with her definition. Combs argues Dr. Hughes describes how victims of sexual abuse or assault have different coping methods, like not using certain words or using minimizing language, and they experience, quote, "mental defeat." But the article that Hughes seemingly relies on doesn't support her opinion, according to Combs. As Combs' defense team writes, the article is a meta-analysis studying the prevalence of PTSD following sexual assault. It found that approximately 75% of sexual assault victims met criteria for PTSD 1 month after an assault, but only 41% met the criteria after 12 months. Both prevalence and severity dropped over the course of a year. The authors concluded that the majority of PTSD recovery occurs within the first few months following sexual assault. The conclusions in the cited article have nothing whatsoever to do with Hughes' proffered opinion about what coping methods are typical among victims. Indeed, if anything, the article undermines Hughes' suggestions that rape trauma symptoms generally last for an indeterminate or indefinite time period. Combs further argues that Holmes may claim victims don't typically report their attacks immediately due to shame, fear, embarrassment, but the article that she cites, again according to Combs, doesn't support her conclusion. Rather, the article suggests there are a whole host of reasons for delayed or non-reporting. It's complicated, it's highly individualized, and there's no, quote, typical response or reasons. But to further support the argument that Dr. Hughes' opinions are not a reliable application of scientific principles, again, this important factor in the overall analysis, Combs also alleges that she hasn't applied her methods to this case, which he explains is required under a specific rule of evidence. Quote, Hughes has apparently not interviewed the alleged victims at all, much less engaged in the sort of psychological diagnostics that her profession demands. As a result, she offers unadorned opinions that can explain the accuser's behavior, even though she's made no effort to exclude alternate explanations. For instance, Combs explains that Hughes will testify that victims of abuse may use drugs and alcohol to numb the pain from the abuse, but couldn't there be other reasons they use substances? As Combs explains more specifically about victim 1 in this criminal case, quote, there will be evidence in this case that victim 1, among others, regularly used drugs and alcohol both in conjunction with sexual activity and otherwise. That may be because she was coping with trauma, or that may be because she enjoyed it. The jury will have to determine which is true based on the evidence at issue, including her own testimony, her contemporaneous text messages seeking drugs, and so on. The question for the jury, in other words, will be specific, not general. But Hughes' proposed expert opinion does not actually shed any light on that specific question because she has made no effort to examine the evidence in this case and thus make any reliable determination whether victim 1's substance abuse was related to trauma as opposed to some other alternate explanation. And from there, we move on to the final point of analysis, where Combs argues that Dr. Hughes' opinions should be excluded under Rule 403 of the Federal Rules of Evidence. What is Rule 403? It's an important one. That the court may prevent evidence from coming into trial if its probative value, meaning its strength in proving something, if its probative value is substantially outweighed by a danger of unfairly prejudicing the jury, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative or repetitive evidence. So what is Combs' argument here? Quote, Hughes' testimony has low probative value. This is a case where the jury will have to judge the nature of a relationship between a man and a woman based on their trial testimony and other evidence, including their communications during the relationship. A jury doesn't need an expert's help to do that. Most of Hughes' testimony involves broad generalizations about intimate relationships that are not beyond the ken of lay jurors. When it comes to the behaviors that are common among sexual assault victims, the most she could reliably say is that there are no typical behaviors. Everyone reacts differently. That opinion, even assuming it would correct some misconception harbored by jurors, does not shed much light on any disputed issues. In this case, the jury will have an unusual amount of contemporaneous evidence shedding light on consent and coercion, including video evidence of the sexual encounters and numerous contemporaneous text messages between Combs and his girlfriends. Hughes' testimony does not and could not shed any further light. The unfair prejudice and potential for confusion is also severe. Hughes' proposed definition of coercion would conflict with the legal definition. Her definition of sexual assault as including non-contact violations such as voyeurism will also muddy the waters, especially given the central role that the videos of the sexual activities involving the male escorts will play at trial. So, again, by the way, they seem to be admitting that those are what the videos will show, and they have seemed to do that before. Beyond this, Hughes' very presence on the stand, even if she disclaims any opinion on the charges, will telegraph to the jury that a leading expert sees enough merit in the government's case to step forward as a government witness. and the admission of Hughes' testimony will force Combs to call his own rebuttal expert, which would divert the jury away from the facts into a sideshow battle of experts. So in conclusion, Combs asked the court to exclude Dr. Hughes' testimony in its entirety. Now, at the time of this recording, no word yet from the judge on this, but there is one more point I have to call out. It seems the defense is also prepared to call an expert of their own should Dr. Hughes be permitted to testify, and that is Dr. Alexander Sasha Barty, who, according to another exhibit that was filed in this case, quote, is a board-certified forensic psychiatrist. As Combs' counsel writes, Dr. Barty would explain that generalizations and vague psychological profiles are of little to no value in evaluating the facts and circumstances of any given case because there is no typical response to trauma and no typical response to rape and domestic abuse. Different people respond differently in different circumstances. For this reason, Dr. Barty would explain the professions of psychiatry and psychology recognize that broad generalities tend to be of limited value in explaining the actual psychology or mental state of any particular individual. Dr. Barty would also opine that Hughes' concept of coercive control is so broad as to be meaningless. So, they have a response to Dr. Hughes. We'll see if this happens, we will see if she testifies, and we will see if Dr. Barty testifies. Could it be a battle of experts? We shall see. But that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.